This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Okay, we're on to Chapter 6, the Law of Tort. Tort is an interesting area. Well, all the law is interesting, but this tort is a civil wrong. It's not a crime, it's not something which is criminal against statute, and it's not a breach of contract, which is what we've been looking at earlier. So the law of tort is a civil wrong. It's a wrong done to persons generally. And there are many types of tort. On page 37 we have trespass against the person, battery, intentional bringing a material object into contact with somebody else, and that doesn't necessarily involve violence. Assault and battery is the sort of thing that you hear that people have been charged with, but battery does not involve necessarily violence. In the case Nash and Sheen, a hairdresser was found to have committed a tortious act. In the case Nash and Sheen, a hairdresser was found guilty of committing a tortious act when she brought into the contact of the hair of her customer a chemical which caused the customer damage. Assault, intentional bringing another person into reasonable fear of battery. But reasonable fear is not merely a threat, but it's a realistic fear. It's, for instance, in a past exam question, threatening someone with a very realistic but toy gun. The person being threatened couldn't realize that it was a toy gun, and therefore they were in realistic fear of personal injury. And false imprisonment involves depriving a person of their liberty. Trespass, as opposed to trespass against the person, trespass on land is entering, remaining, or placing objects on another person's land. But some people are allowed to by statutory authority. For instance, the electricity board may have to cross your land in order to get to their electricity substation. Nuisance, causing distress to another by noise or by smell. There was a case in the UK newspapers about 6 years ago where a young girl was playing Britney Spears records from 6 o'clock in the morning until 1 o'clock the following morning at a very loud volume, and her neighbours complained, and the young lady told them to go away. The local authority came round and measured the noise levels, and they also served notice on her to say, please stop playing Britney Spears at these loud volumes for 6 o'clock and from 6 o'clock in the morning until 1 o'clock the following morning. But she ignored those instructions, and it was taken to court. And the court said, you cannot play Britney Spears before 9 o'clock in the morning nor after 10 o'clock at night. But she continued. So she went back to court again, and this time the court said, you're going to go to prison. And she went to prison for 3 weeks. That's a penalty, I suppose, of playing Britney Spears records. Defamation, for instance, libel and defamation slander are two different types. Libel is in a permanent form. It used to be just written form, but now if it's in permanent form, then that's a crime. Slander is where you talk and ridicule or defame somebody else. It's not permanent, and that is a civil wrong. Deceit, deliberately misleading another into a detrimental position. Deceiving may be the cause, and I'm only saying may be the cause, of some of the more recent high-profile corporate failures. I'm thinking in terms of Barron's and Lehman Brothers in America. Passing off is the use of a similar name in a similar business, such that confusion is likely to result in the minds of the public. We'll come across passing off in greater detail when we'll start looking at company law and choice of names for companies. Negligence, this is one of the major areas about which accountants need to be most careful, and there'll be substantially more of this later on page 41. Tort generally, negligence generally. 3 things are necessary to be established if a person is successfully to be able to claim negligence. First of all, they must show that a duty of care exists. Secondly, that duty has been breached. And thirdly, that as a result of that breach of duty, there has been a consequential loss or damage or injury to another party. We all owe a duty of care to our legal neighbours. Car drivers are required and have a duty of care to other road users. They're required not to drive in a negligent way. Doctors, similarly, have a duty not to kill their patients. Accountants, particularly, have a duty to beware of the implications and the impact of their audit reports and other reports on third parties. Who are your legal neighbours? They are those people who are so directly affected by your acts that you should have them in mind as likely to be affected when you commit those acts. There is a wonderful case, Donoghue and Stevenson, about a young lady who was bought a drink by her boyfriend. He poured her half the drink and she drank that, and then he poured the remaining half. And as he poured the second half, something came out of the bottle. And when she looked at it and said, "What's that?" he looked and said, "It looks like the decomposing remains of a snail." At which point she then vomited and was caused great mental distress as well as physical distress. And the question arose, who can she sue? There was no question that she was going to sue her boyfriend, but what about the cafe owner that had served them the drink? Well, no, the cafe owner could also not be found liable because the cafe owner had not put the ginger beer into the snail into the ginger beer, and was therefore could not be held liable. So the question then comes back, who can she sue? And the question went to the House of Lords. Was it available for her to sue the manufacturer? And the House of Lords said, yes, you can. So the ultimate consumer of a product is able to sue the manufacturer of that product because the manufacturer owes a duty of care to their customers. It's now more recently been developed into a three-stage test. Reasonable foreseeability, proximity, that is, the person is your legal neighbour, and is it fair, just and reasonable to impose a duty of care? The second thing to establish is breach of the duty. A greater degree of care is needed if the risk of injury is high. In the case Glasgow and Taylor, some children were playing in the park owned by Glasgow Corporation, and they ate some berries from the trees, the bushes which were growing in the park, and the berries were poisonous bushes, and therefore the children fell ill. And it's held that Glasgow Corporation was liable to make sure that berries growing in their parks were not available and accessible to children who do need protection. So Glasgow was found to be liable. In addition, we have to take into account the seriousness of the risk. And in the case Paris and Stepney, we have a welder, a working man who is using welding equipment, but he was not provided with safety goggles. And the man he had already lost the sight of one eye. The seriousness of the risk is therefore quite clear. If this man were to lose a second eye, then that would be disastrous for him. He would no longer be able to see at all. And a spark flew from the welding equipment into his one good eye, and as a result, he lost the sight of that second eye. Quite right that he should be able to sue the Stepney Council. Thirdly, we have to take into account the practicality and the cost of risk avoidance. In the case Latimer and AEC, a warehouse was flooded. The owner of the warehouse took reasonable steps to mop up the water from the floor, and he put sawdust down to soak up the surplus. But to close the warehouse, to close the production facility, would be very expensive. Whereas they mopped up and sawdusted as much as they could, they didn't cover every square centimetre of the floor area. And Latimer walked on a wet bit and slipped and injured himself. So he sued AEC. And the court said, no, it's not fair, just and reasonable to hold Latimer liable. They did their best, and it would have been unreasonable to insist that every drop of water was cleaned up. We take into account standard practice. There is a case Leigh, L-E-I-G-H, and Sim, S-I-M-M. Lee and Sim. This was about a rugby player who, with a flying tackle, actually missed his man and flew off the field of play. He went 2 meters and 5 centimeters and banged into the concrete retaining wall. So now he sues. But Lee, the Rugby League Football Club, Lee were able to establish that standard practice and standard laws within the game required that a concrete wall should be no less than 2 meters away from the playing surface. Theirs was 2 meters and 3 centimeters. Unfortunately for Sim, his flying tackle took him 2 meters and 5 centimeters, so he banged into the concrete wall and was injured. In that case, Lee were found to be not liable because their wall was further than was the minimum requirement of the rugby league. We need to take into account the social benefit. For instance, an accident caused, the next word should be by, an accident caused by an emergency ambulance. If an emergency ambulance is rushing injured people to hospital and itself has an accident, the social benefit of an accident rushing people to hospital is rather greater than the potential reasonable foreseeability of an accident caused by that emergency vehicle. Professions, for instance the ACCA, establish their own levels of care. There is a bit of Latin, res ipsa loquitur, in the case richly and fold. Sometimes the facts of the case speak for themselves. There's no question of negligence because the facts themselves prove it. In the case richly and fooled, a car which was on the wrong side of the road caused an accident and injured people. Well, the fact that it was on the wrong side of the road demonstrates without question that the driver was being negligent, and therefore the driver was liable. Mahon and Osborne is another example of res ipsa loquitur. If you go to hospital for an operation, you don't expect to come out from that hospital with some bits of medical equipment having been left inside you. In the case Mahon and Osborne, the surgeon inadvertently, negligently, had left a swab inside the patient, and that caused the patient injury. The third thing to establish is causality and the possibility of breaking the chain, and the courts will apply the but-for test. In the case Barnett and Chelsea and Kensington Hospital, a night watchman, went into the hospital near where he was working and complained of stomach pains. The doctor on call, looked at him and said, "Oh, you should be all right. You go home and go and see your own doctor in the morning." What he had failed to recognize was that this night watchman was suffering from arsenic poisoning and later died. So Barnett's relatives sued Chelsea and Kensington Hospital, but it was established that if the doctor at the hospital had treated him, Barnett would still have died. He was suffering from arsenic poisoning, and there was nothing that the doctor could have done. So but for the doctor's actions, he would still have died. And in the case Wiltshire and Essex, a premature baby was born injured, and it was established that there were at least 6 reasons why the baby should have been born in an injured condition. So the hospital was again able to avoid responsibility or liability. In a recent case, Fairchild and Glenhaven, the injured party was suffering from asbestosis, from breathing in asbestos fibres. It was established that it could not possibly be identified that Glenhaven was the sole cause of this asbestosis. The man had been working at a number of places with asbestos fibres and could have breathed them in at any of them. The court held that not only should Glenhaven be liable, but so should the others. Novus actus interveniens, another piece of Latin. It means something new intervenes and breaks the chain of causality. In the case of McHugh and Holland, the acts of the injured party were unreasonable. McHugh had a weak leg, but refused all assistance to help him up a flight of stairs. Halfway up the flight, his leg gave way and he fell down the stairs and was injured. It's his own fault. He should have asked for assistance. The acts of a third party increased the damage. In the case Lamb and Camden, a property was vacated because it had been damaged. But in its damaged, vacated state, squatters occupied the premises and caused even more damage. So Lamb, the owner, sued Camden, and Camden said, well, we're not liable for all of this damage, only the damage that was caused up until the point it was vacated. The remainder of the liability should lie with the squatters. In the case of an act of God, a ship was being taken from one port to another in order that it could have repairs done to some damage which it had already suffered. But on the way to the port, going for repair, a storm came and caused even more damage to the ship. It was determined that Norway should only be liable for the pre-storm damage. Reasonable foreseeability and the remoteness of the foreseeability. A number of cases here. The Wagon Mound was a case about a company of welders who were working on a pier in Sydney Harbour in Australia. Across the other side of the harbour there was a ship taking on oil, and some of that oil was discharged into the water by accident. The welders saw the oil as it drifted across Sydney Harbour and called in an expert and said, if we carry on welding, are we likely to set fire to Sydney Harbour? And the expert looked at the oil and said, no, this oil is not flammable. Your welding sparks are not likely to cause it. It would need something new to intervene in order to set fire to the oil. So they carried on. One of their sparks landed on some cotton waste, and that acted as a wick, very much like a candle. So the cotton waste caught fire, and the burning cotton waste then set fire to the rest of the oil in Sydney Harbour, and the pier was damaged as a result. Was the fire reasonably foreseeable? The answer is no. The damage that could be foreseen was the pollution. The fire and the cotton waste was novus actus interveniens. Jolly and Sutton involved a derelict boat, and children being children, they found this boat and they started playing on the boat, and one of them was injured. It was determined that the local authority, a district of London called Sutton, was liable, that they should have realised that children do play on derelict boats, and the derelict boat was in a state of a dangerous condition, and that with people playing near that, then they could very well be injured. It's not every incident which people or defendants find themselves found to be liable for damages and for paying contributions. Sometimes the acts of the plaintiff themselves cause an additional or extra injury. One of the defences is contributory negligence. The acts of the defendant caused additional injury, or even caused the entire injury. In the case Sayers and Harlow, yet again another district of London, Sayers was using a public toilet, and the lock on the door broke when she was trying to get out. Now, if you or I were using a public toilet, would it not be sensible just to stay there and shout, help, help? But not Mrs. Sayers. She decided that she would get out of this public convenience, so she climbed onto the toilet, and she put her foot on the cistern behind the toilet, and she put her other foot on the toilet roll holder. Yes, the toilet roll holder rolled, and she found that her foot had slipped off the toilet roll holder, and she fell down and was injured. She now sued Harlow District Council. If all she had done was stay in that locked cubicle and waited for assistance, then there would have been no injury to her. She was contributory negligent. Another defence is volenti non fit injuria, another piece of Latin. It means, to he who is willing, there can be no harm. In the case ACCA and Shotwell, the Shotwell brothers were experts in explosives and demolition, and they had been asked to put their explosives into a building to destroy it. When they had embedded their explosives into the building, they then led their wire away to the plunger which would explode the explosives, but there wasn't enough. So instead of going to get more wire, some more cable, they decided that they would risk it anyway. So they pushed the plunger, the building blew up, and bits of the building landed on them and injured them. Shotwell sued ACCA on the basis that ACCA were negligent. Is it fair, just, and reasonable that ACCA should be held liable for their experts' own negligence? Another couple of cases. The case Haynes and Harwood. That's Haynes and Harwood. It involves a horse-drawn milk delivery cart. It was in a village, and the milkman had got off to leave some bottles at the house at the top of the village street. And for whatever reason, the horse took fright and started to run down the village street. The run got faster, and the horse was eventually galloping. An off-duty policeman saw the horse coming towards him, and looked behind and saw a group of young children playing in the village street at the far end of the village. If that horse had continued, it could have been like a bowling ball in a bowling alley. A major strike, children flying all over the place. So the off-duty policeman, Haynes, stepped in front of the galloping horse, grabbed it round the neck, and brought it to a halt, but he was injured in the process. So he now sued Harwood, and Harwood said, no, you were a willing volunteer, and to he who is willing, there can be no harm. Volenti non fit injuria. But the courts looked at the situation and said, we have to reward heroism. People who are heroes should not be unable to claim injury against persons who leave a horse unattended. So we will reward and award the hero. In a similar case, the case Cutler and United Dairies, that's Cutler, Cutler and United Dairies, the village street was there, and the horse-drawn milk delivery cart was there, and again the horse took fright. But on its way towards the children playing in the dust at the end of the village street, the horse turned right into a ploughed field and galloped around the field. Bottles were flying everywhere, damage to the grass and the soil in the field, and Cutler saw what was happening and went into the field and chased and caught the horse and was injured in the process. He now sues United Dairies and says, as a result of my actions, I have become injured, and it was your responsibility to look after the horse. And the court said, what damage was going to result if this horse had been allowed to continue to gallop around the field? What danger was there? What threat of injury was there to human life? Okay, there were some broken milk bottles. Okay, there was some damaged grass and some trodden soil. But you're a meddler. You have interfered when there was no need for you to interfere. To he who is willing, there can be no harm. You took it upon yourself to be volenti, and volenti non fit injuria, to he who is willing, there can be no harm. Now that's the end of tort generally. What we next need to consider is tort as it relates to the accountancy profession. And there are a number of cases set out on page 41.